The petitioners contended that the impeachment proceedings against His Excellency Rigathi Gachagua was tainted by actual bias, apparent bias, conflict of interest, and predetermination on the part of the speakers of the National Assembly and the Senate, members of Parliament, senators, and other constitutional actors involved in the impeachment process. It was their case that various public statements, political conduct, and procedural decisions demonstrated that the outcome of the impeachment had effectively been determined before the proceedings commenced, and that the constitutional actors involved had failed to approach the process with the impartiality and openness required under Articles 27, 47, and 50 of the Constitution. The constitutional foundation of the petitioner's claim lies principally in Article 27, 47, and 50 of the Constitution. Article 27 guarantees equality before the law and the equal protection and equal benefit of the law. Article 47 guarantees every person the right to administrative action that is lawful, reasonable, and procedurally fair. Article 50, sub-article 1, guarantees every person the right to have any dispute that can be resolved by the application of law determined in a fair and public hearing before a court, or where appropriate and independent and impartial tribunal or body. The constitutional requirement of impartiality is not confined to court of law. Whenever a constitutional body exercises adjudicative, disciplinary, investigative, or quasi-judicial authority affecting rights, interests, status, or public office, the process must comply with constitutional standards of fairness, impartiality, and procedural propriety. This principle was affirmed by the Court of Appeal in Sholei versus Judicial Service Commission and 3 others in 2013, and the Judicial Service Commission versus Mbalu Mutava and another Civil Appeal number 52 of 2014, where the court emphasized that constitutional and administrative decision-making processes are subject to the requirements of procedural fairness and natural justice. In Mbalu Mutava, which I've mentioned above, the Court of Appeal observed that Article 47 transformed the common law principles of natural justice into constitutional imperatives, such that whenever public power is exercised in a manner affecting legal rights, status, or legitimate expectations, constitutional standards of fairness become directly applicable. In Sholei case, the Court of Appeal reaffirmed that public bodies exercising disciplinary or quasi-judicial authority must act fairly and impartially, and that public confidence in constitutional institutions depends not only on actual fairness, but equally upon its appearance. The rule against bias is one of the oldest and most fundamental principles of natural justice, embodied in the maxim Nemo Judex in Causa Sua, that no person shall be a judge in their own case. Historically directed at preventing decision makers from participating in matters in which they held a personal, financial, or proprietary interest, the doctrine has over time expanded to encompass circumstances giving rise to a reasonable apprehension that a decision maker may not approach a matter with the requisite impartiality, even in the absence of any direct personal interest. The modern test for apparent bias was authoritative stated by the Supreme Court in Rai and 3 others versus Rai and 4 others, 2013, KLR, where the court adopted the objective test and held that the inquiry must be conducted from the perspective of a fair-minded and informed observer. The court emphasized that allegations of bias cannot be founded upon speculation, conjecture, suspicion, or dissatisfaction with the outcome of proceedings. There must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker may not bring an impartial mind to bear on the subject. The Supreme Court reaffirmed and elaborated upon these principles in Kaplana, Rawal, and 2 others versus Judicial Service Commission in 2016. Observing that the question is not whether a party genuinely believes that a tribunal is biased, but whether a reasonable and informed observer, having considered all relevant facts, would conclude that there exists a real possibility of bias. The court further recognized that constitutional institutions must be protected from unsubstantiated allegations capable of paralyzing their functioning, and accordingly insisted upon an objective evidentiary foundation before a finding of bias can be made. Similarly, in Tunoi and another versus Judicial Service Commission and another Civil Appeal number 6 of 2016, the Court of Appeal reaffirmed the enduring principle first established in R versus Sussex Justices Ex parte McCarthy, 1924, 1 KB 256, that justice must not only be done, but must manifestly and undoubtedly be seen to be done, and underscored that public confidence in constitutional institutions depends significantly upon the appearance of impartiality and not merely its substance. From these authorities, several important principles emerge. First, the test for apparent bias is objective, not subjective. Second, the inquiry must be conducted from the standpoint of a fair-minded and informed observer. Third, mere suspicion, political disagreement, dissatisfaction with a decision or an adverse outcome does not, without more, establish bias. Fourth, and critically, there must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker did not or could not approach the matter impartially. Jurisprudence further establishes that bias and predetermination, though related in concept, are legally distinct. Bias concerns the existence of actual or apparent partiality or on the part of the decision maker. Predetermination concerns a state of mind in which the decision maker has effectively closed their mind to the evidence and argument and reached a final conclusion before the process has run its course. The distinction was illuminated by the English Court of Appeal in Lewis versus Redder and Cleveland Borough Council in 2008, where the court drew a clear line between predisposition and predetermination. Decision makers may legitimately hold predispositions, inclinations, or preliminary views on matters before them. That is the inevitable consequence of experience and engagement in public affairs. What the law prohibits is predetermination, which is a state of mind so close to persuasion that no amount of evidence or argument is capable of altering the ultimate outcome. In light of the authorities that we have cited, we hold the view that the mere fact that members of parliament or senators publicly supported or opposed the impeachment of His Excellency Gachagua cannot, standing alone, establish constitutional bias. To hold otherwise would render impeachment proceedings practically unworkable and would be inconsistent with inherently political character that the Constitution itself recognizes in such proceedings. Legislators are not expected to approach impeachment as blank slates, devoid of political opinion or prior knowledge. What the Constitution requires is that they remain genuinely open to considering the evidence, listening to argument, and discharging their constitutional responsibilities in good faith and within constitutional limits. We are accordingly not persuaded by the proposition that bias may automatically be inferred from the fact that legislators belong to particular political parties, support particular political positions, or publicly express their views on political matters that may not necessarily be the views of the accuser. Such circumstances may demonstrate predisposition, but predisposition, as the authorities make clear, is not synonymous with predetermination.